On May 22, 2026, USCIS posted an important notice on its official website. The title, in simple words, says that adjustment of status will be granted only in extraordinary circumstances. After this notice came out, it quickly caused a lot of concern. Our firm also received many questions from clients. We understand why people are worried. So today, let's take a clear look at what this new policy is really saying.
Let's look at the USCIS notice first. Two parts stood out right away. First, USCIS says it is returning to the original intent of the law. In plain English, USCIS is saying that if someone is in the United States temporarily and wants a green card, the normal route should be to leave the U.S. and apply through a U.S. consulate abroad, unless there are extraordinary circumstances. USCIS also says this policy is meant to make the immigration system work as the law intended, instead of encouraging people to use loopholes. Then, USCIS goes further. It specifically mentions non-immigrants such as students, temporary workers, and visitors on tourist visas. These people, USCIS says, come to the United States for a short time and for a specific purpose. Their stay in the U.S. should not automatically become the first step toward a green card. So it is easy to understand why people are worried. F1 students, H1B workers, B2 visitors, employment-based applicants, and marriage-based green card applicants are all asking the same questions. Is this about me? Can I still file I-485? Do I now have to leave the U.S. and go through consular processing? But let's stay calm. This policy does not cancel I-485. It does not mean everyone must leave the United States for consular processing, and it does not mean every case will be denied. The real point is this: USCIS is treating adjustment of status less like an automatic right and more like a discretionary privilege. Meeting the basic requirements may let you apply, but it does not guarantee approval. Does that sound a little confusing? Let's do what we always do: go back to the law. But before we analyze this new policy, we need to understand what it actually is. The name is Policy Memorandum. So what is a policy memo? In simple terms, it is a guidance document USCIS gives to its own officers. It tells officers how to understand the law, what factors to look at, and how to exercise discretion when they review cases. It is not a new law passed by Congress. It is not a formal regulation. It does not cancel I-485, and it does not automatically change an applicant's legal eligibility. But it still matters. Why? Because it can affect how immigration officers review adjustment of status cases going forward. It can affect how they read the law, how they evaluate the facts, and how they decide whether to exercise discretion in favor of the applicant. Next, let's look at the policy memo itself. It is not long, only 6 pages. The first part focuses on the legal background. USCIS cites many older cases to repeat one basic point: adjustment of status is not approved just because the paperwork is complete. It is still subject to USCIS discretion. But this is not a new law. INA Section 245 has always said that a person's status may be adjusted, not that it must be adjusted. It also says the decision is made in the government's discretion. So this memo is really bringing an old principle back to the front and telling officers to apply it more seriously. Then, the memo focuses on people who enter the United States as non-immigrants, such as students, temporary workers, and visitors on tourist visas. USCIS is saying that these people usually come to the United States for a short-term and specific purpose. When that purpose ends, the normal expectation is that they leave. If they want to immigrate permanently, the regular path is usually to apply for an immigrant visa through a U.S. consulate abroad. I-485 is different. It allows a person to stay in the United States and complete the green card process without leaving. So going forward, if someone chooses adjustment of status, the officer may ask one more question. Why does this case deserve adjustment inside the United States instead of going through the regular consular process abroad? This does not mean the memo targets only one type of visa. It also does not mean that all temporary visa holders, such as F1 students, H-1B workers, or B-2 visitors, can no longer file for adjustment of status. The risk levels are different. For example, H-1B is a dual intent status. An H-1B worker can keep a temporary work status and still pursue a green card that is very different from someone who enters the U.S. on a tourist visa and quickly files for adjustment of status. Overall, the discretion review may become stricter and more complete. Prior overstays, unauthorized work, failure to maintain status, conduct that does not match the original purpose of entry, and false statements may all become negative factors. And because discretionary decisions are often hard to challenge in court, the key is to prepare early. Clean up the immigration history, explain any negative facts, and build strong positive reasons for USCIS to approve the case. I'm Ava Lee, the immigration attorney at Ava Lee Law PLLC. We help you prepare for your green card case and interview, so your answers are clear, steady, and consistent. See you next time.